Good morning, ladies and gentlemen, and a very warm welcome to this shipping special in Quadrant Chamber's Quadcast series. This is the first of two shipping specials in July in which members of Chambers are going to be looking at the special issues thrown up by the unfortunate coronavirus pandemic for shipping and international trade. This morning's webinar concerns the sad tale of a voyage marred by COVID-19 illness and ultimate death, and the legal problems which it throws up. I'd like to stress that it's an entirely hypothetical scenario, but it's based on a mix of cases in which we four have been involved in the last few months of lockdown. But we think that the scenario we've painted either will be resembled or will be reflected in future scenarios given the continuing uncertainty, second wave viruses, some countries not emerging from their first wave virus. Because shipping is at the sharp end, with its international scope and with the huge supply chains which potentially carry virus from jurisdiction to jurisdiction. Now, you should have had a detailed hypothetical set of facts, which I hope you've all read, but if you haven't, let me summarise what this case is about. We're going to consider a voyage charter party. We could have considered a time charter party, and the sort of issues we're going to be looking at, it would be interesting to get any questions on it, can be mirrored in certain aspects in time charter parties, but there are some differences. So the voyage is from South Africa, carrying a perishable cargo, to China. Unfortunately, Port Elizabeth, like everywhere else, is affected by COVID-19. There, the master and the pilot are probably infected. Possibly, we'll consider that as we go along. The chief officer then is affected and falls ill. The passage plan, which is his responsibility to pass the master, is left undone on the chart table. The vessel sets sail. En route, the chief officer worsens. How much worse, we'll have to consider. It doesn't seem from the hypothetical scenario that anybody thinks he's in a life situation, but he's plainly not very well. The master decides to turn off the contractual voyage to the nearest port, which he's sailing past, which is 12 hours steaming. The nearest port is in lockdown. Whether the master knew that or not when he turned is possibly a matter we'll have to consider. That port, therefore, has a regime which is no one in, no one out, no one on, no one off. The master waits, notwithstanding that position. The chief officer gets worse, and sadly dies. Notwithstanding the port is still in lockdown, the master waits still further now in order to try to disembark the corpse of the chief officer. And those are the facts, and ultimately he sets sail. So those are the facts we're going to be considering today. I'm Simon Rainey, and I'm going to be discussing these facts with John Russell, Nichola, Warrender, and Andrew Leung, all from Quadrant Chambers. And we want to consider three particular themes or aspects. First of all, unseaworthiness. How does this factual mix impact upon the seaworthiness of the vessel as she leaves Port Elizabeth? Secondly, the vexed questions of deviation. The master leaves the contractual route. Is this a deviation position? And then the equally vexed position of safe ports. Are we in a safe ports position? And if so, why and how would you argue it? We're going to start with unseaworthiness, and we're going to field any questions we have at the end. Thank you very much to those that are already sending through questions. There's some very interesting questions, which I hope I will be able to duck, and we'll deal with those at the end. So John, let's start with unseaworthiness. You and I have done our fair share of Hague Rules cases, latterly Article 3, Rule 2, Volcafe and CSAV, with the burden of proof. I know that in a case we're doing, you're arguing that Volcafe and CSAV applies equally to seaworthiness issues in Article 3, Rule 1. I'm reluctant as I am to mention this, but fresh from your victory in the CMA CGM Libra on passage planning and unseaworthiness, can I ask you, is there any unseaworthiness aspect here? Where are we looking? Are we in Article 3, Rule 1 territory?
I think we probably are. And just as a preliminary word in relation to the liability regime, what we've got here is a voyage charter incorporating the Hague Visby rules. And often there's a tension between the GenCon form, and in particular the owner's responsibility clause, and the Hague rules. For present purposes, I'm going to assume that this is what you might call a full fat incorporation of the Hague Visby rules. Yeah. And so the liability regime is the rules regime rather than the clause 2 regime of the GenCon form.
So effectively 3.8 trumps clause 2 of the GenCon form.
Assuming that 3.8 is incorporated, okay. That means that the owners can't rely on the more limited regime in the owner's responsibility clause. So if we're looking at a Hague or Hague-Visby regime, there are two distinct sets of obligations on the owners. The first is the 3-1 obligation to make the vessel seaworthy, or to exercise due diligence to make the vessel seaworthy before the commencement of the voyage. And in relation to that obligation, of course, the 4.2 exceptions don't apply.
Yeah.
And then secondly, you have the Article 3.2 obligation to take reasonable care of the cargo, in relation to which the exceptions do apply.
John, can I ask you a question? Isn't navigational fault always an exception?
Well, not at the moment is the answer to that. That was essentially the argument that the owners sought to run in the Libra case.
Yeah.
They argued that because the passage plan was defective, that was a navigational matter and was entirely out with the scope of Article 3.1. They said the passage planning was navigational and therefore wasn't a matter going to on seaworthiness at all. That was given fairly short shrift by the Court of Appeal. The Court of Appeal said that the relevant analysis was not a functional analysis, it was a temporal analysis. And if there is a defect which means that the reasonably prudent owner wouldn't allow the vessel to go to sea before the commencement of the voyage, then the vessel is unseaworthy, regardless of what the cause of that defect is, whether it can be categorized as a navigational matter or not. So as it stands, the law is pretty clear that the test is temporal, or the dividing line is temporal rather than functional. Having said that, the owners in the Libra case have applied for permission to appeal to the Supreme Court, and that application for permission is still outstanding. So it may be that if we're back here in a year's time or 18 months' time, I'll have to give a rather different answer to that question.
I'm going to remember that question then.
Good to see you looking less smug, John.
Worried boy. So the test, as I say, is whether there is a defect in the vessel such that the reasonably prudent owner wouldn't allow the vessel to go to sea if he was aware of that defect before and at the commencement of the voyage. And it seems to me that in this case, there are at least two respects in which it is arguable that the vessel wasn't seaworthy at the commencement of the voyage. First of all, there was no passage plan. And secondly, the chief officer was ill, and we now know was ill with COVID-19.
John, I know you were in the Libra, but why do we care about the passage plan? Did it make any difference in this case?
Good one, Andrew.
No, I think that's a very good point, actually. While of course I'm very glad that this entirely hypothetical example has had passage planning thrown into the mix.
John, you told me to do that. Don't lie.
Nichola, don't put your hands up to the scenario.
So you're quite right, Andrew. On the facts of this case, passage planning is irrelevant. I think there is actually quite a serious point there, though, which is that there's been quite a lot of consternation amongst owner circles and P&I clubs and so forth as a result of the Libra decision. And it's seen as putting into jeopardy the navigational fault defense. However, I'm not sure that it's in fact such a matter of concern as sometimes made out, because it's going to be difficult in most cases to tie a defective passage plan into a subsequent casualty. I think causation is always going to be an issue where there are allegations in relation to defective passage planning, and in most cases, as I say, I think it's going to be difficult to successfully argue that a defective passage plan was causative of subsequent casualty events. And certainly, as you say, on the facts of this case, there's no suggestion that the passage planning was in any way causative of what happened next. But that can be contrasted, of course, with the illness of the chief officer, because it is that illness which clearly led to the subsequent events.
Doesn't the unseaworthiness, if you're talking about that, have to be in respect of an attribute of the ship? And what is an attribute of the ship when we're looking at the chief officer's illness?
Aha!
Yes, well, that's an interesting question, and whether the defect has to be an attribute of the ship or not. And the answer is that it's not clear. There's a line of authority, Aqua Charm, Court of Appeal, and the Apostolis, which suggests that the defect has to be an attribute of the ship, and that's picked up in most of the textbooks. The Court of Appeal left that question open in the Libra decision. It was raised by the owners, and the Court of Appeal suggested that the attribute test might be an unnecessary gloss on the basic unseaworthiness test, but didn't have to decide it on the facts of the case, because there's a defect in the chart, and there's clear authority that if there has to be a defect in an attribute, then the chart is an attribute of the vessel. It seems to me in the same way in this case, whether or not the defect being in an attribute of the vessel is part of the test, that test would be satisfied in the facts of this case, because the illness of the chief officer, it seems to me, would be an attribute of the vessel in the same way as incompetence of the crew, or a delinquent crew and so forth, is a feature of or is an attribute of the vessel.
It's not like an external factor, is it, which impinges upon the vessel? Take a neutral example, John. A crane which falls from the shore side onto the deck of a ship. Is the crane part of it becomes an attribute of the ship for the purposes of the due diligence obligation? So here it could be argued there's an extraneous circumstance which comes on board the vessel, i.e. a virus, which no one knows about, which infects the chief officer. Now, you don't need to answer the crane question, because you've now got a trial about that in November. But
I think that at an initial stage, you might say there's no defect in the attribute of the ship. But in this case, before the ship departed, so before the commencement of the voyage, the chief officer himself was ill. And it seems to me that just in the same way as an incompetent crew or delinquent crew is an attribute of the vessel, so a crew member who is seriously ill is going to constitute an attribute of the vessel.
Yeah, and you get into those old cases where either you had an alcoholic master or a master who was completely inebriated at the time of setting sail and then hit something just as going out. Why is it any different? Yeah,
I think that's right. I think that the more difficult question in this case is actually going to be due diligence, and so it seems to me that there's a pretty strong argument that the vessel was unseaworthy by reason of the chief officer's illness. The question is going to be whether there's been a failure on the part of the owners, or those to whom they had delegated responsibility for making the vessel seaworthy, to exercise due diligence.
Right, so what about the master and the second officer? They could see the chief officer was ill. Shouldn't they have done something?
Good question. I mean, that really raises the delicate point, I think, for you, John.
Yeah, absolutely. And I think that this is where perhaps the law is least certain at the moment. It's obviously very clearly established that the obligation to exercise due diligence is non-delegable, in the sense that the owners will be responsible for a failure to exercise due diligence on the part of anybody to whom they have entrusted responsibility for making the vessel seaworthy in the relevant respect. But that raises, I think, difficult factual questions as to the extent to which the owners have in fact delegated responsibility for a particular task. I think in this case, it's reasonable to infer that the owners have delegated to the master the task of ensuring that the crew are fit and healthy before the vessel commences. And so if on the facts, the master, exercising reasonable care, should have identified the fact that the chief officer was ill, that would lead to a finding that there had been a failure to exercise due diligence for which the owners are responsible. I think it gets more difficult, so the further down the food chain you get, if you like. I mean, you can take a case where the chief officer took to his cabin, knew himself that he was unwell, but didn't let on to anybody else on the vessel, so the master didn't know. Query whether it could be argued that the owners have delegated to the chief officer himself the task of making sure that he is healthy at the commencement of the voyage. And that sounds rather more artificial.
Does it? I mean, you're in an orbit issue there. I mean, as a senior deck officer, isn't he in some way responsible for the health of the vessel? So, for example, if he saw a stevedore coming on board who was obviously very infected or very ill or something like that, he would have a responsibility to the ship. It being delegated to him as the senior deck officer might be different if you had an AB, but he would be the person to the care of the vessel's health would be delegated, just as much the master. The master may be asleep in his cabin, chief officer on duty. Why isn't the chief officer responsible for his own health as well as a stevedore coming on board?
Yeah, I think it may be a question of fact and degree. You can certainly make a case, I think, for the chief officer being responsible for the health of the vessel.
It's difficult, isn't it?
But let's I mean, if you go down to the third engineer, if the third engineer is unwell, have the owners delegated to him any responsibility for making sure that the crew, including himself, is responsible? And so I think once you get down to that level, there's a certain degree of artificiality about it. You see also in cases where, for example, a small number of the crew are, let us say, in league with drug smugglers and have smuggled drugs on board or taken drugs on board, and the vessel is subsequently detained. Let's assume that the owners and the officers are entirely unaware of what these crew members are doing. Can it be said that the crew members have an obligation to, again, to shop themselves, to put their hands up and say to the owners, we are engaged in drug smuggling? Have the owners delegated to the crew members the task of ensuring that there are no drugs on board? So I think that once you get, these are difficult issues that will be fact sensitive, and I think that the different tribunals, different judges may approach them in different ways.
Yeah.
Anyway, we seem to have gone off. We seem to have deviated into drug cases, which might be a good way to return to the facts of this case. Simon, the vessel fairly obviously deviated during the course of the voyage, didn't she?
Oh, John, I think you're rather assuming too much there. Let's call it neutrally to start with a departure from the voyage. Plainly, the vessel did depart from the voyage because she left the only contractual route to a port which was 12 hours off it, either behind or to port or starboard. And in those circumstances, the principles of deviation are obviously potentially engaged. What is a deviation? Let's just remind ourselves. It's sometimes not a topic we have to look at very often, but it's coming up quite a lot in this era. A deviation is any unauthorized departure from the contract route. And the contract route may consist of different routes, but if there is a definable contract route, as soon as you depart from it, that is potentially a deviation. To take a simple example, assume the contractual route is the A12. As soon as you turn off the A12, you are potentially deviating. And unless there's a permissible exception which allows you to do so, you will be deviating as soon as you leave the course. That's one aspect of deviation, which is plainly engaged in this case, potentially. The other aspect of deviation is if a vessel delays in the voyage. If the vessel delays unduly in the voyage, then that is potentially a deviation. Delay is more difficult because you have to ask whether the delay is such as to make the voyage of a completely different length. And vessels take a long time. This is a long voyage from South Africa to China, so that might be more difficult. But in the context of leaving the route, then we're plainly in deviation country. Then we need to look at what are the permissible exceptions. Well, we've got the GenCon form in our case, so we've got clause 3. That's very limited. Call up ports in any order doesn't help. The Duke and Ward and all those old cases, that's limited to the contractual route. So the only one is saving life. That's the only exception which could potentially apply here. The other one is that the Charter Party, as John's mentioned, incorporates the Hague Rules. So if it incorporates the whole Hague Rules in terms of full fat Hague Rules, then we've got Article 4, Rule 4. Article 4, Rule 4 is a much wider scope of deviation. It includes saving life, but it also includes deviation, which is any reasonable deviation. Now, what does that mean? Go back to the old cases. Lord Atkins' analysis in Stagline and Foskell and Magno, I think, is still the leading case. And what he said is, the true test is, and I have to read this because I can't remember it, the true test seems to be what departure from the contract voyage might a prudent person controlling the voyage, and these words are important, at the time make and maintain, so that's looking not only at the time you make the decision, but then the perseverance, if I can put it that way, in the decision after the decision has initially been made, having in mind all the relevant circumstances existing at the time, so you look at it temporally, and the circumstances at the particular time, and having taking account of all interests of the parties concerned without any particular person's interests being predominant. So I think we have here, just as John said in relation to due diligence, we have here, to use Bernard Ricks's favourite phrase, a multifactorial assessment of what is in fact engaged. But the burden of proof, as soon as that vessel leaves that route, is on the owners to justify that deviation under one or other of those two provisions.
Does that really arise in our case when the vessel arrived at the discharge port and the charter party was performed? Yeah,
that's interesting, because the hypothetical scenario, excellently drafted though it is, it seems that there's no problem. The vessel proceeds to destination and the cargo. And so the owners, I think, were lucky here, for reasons we might come to. But the consequences of deviation, let's take another case, can be really pretty severe because of the remedies to which it gives rise. And we need to start from the fact that if you deviate, you are breaching a condition of the charter party. The condition of the charter party is that thou shalt proceed by the contractual route without unreasonable delay. That's a condition. So if you're in breach of condition, as we all know, you have an instant right of termination. Doesn't matter how grave the breach is or how serious, even a minor deviation will allow you, because it's a breach of condition, to terminate the charter party. And that leaves the owner, if there is a termination, in a very, very tricky situation. He's still got the goods on board in our voyage charter party situation. He's still a bailee of them. He now is a common law carrier, so he's strictly liable for the goods, save three exceptions: act of God, restraint, act of Queen's enemies, and inherent vice. Otherwise, he's effectively a de facto insurer of the goods. Now, if the market is moving in a particular way, and I don't think we've seen this, I don't know if it's interesting to see what the audience has seen it. If the market is moving in a particular way, very attractive for a charterer when learning 3 hours off the contract route, and the master finally radios saying, I've left the contract route, to say, now what are my options? Here, that doesn't seem to have happened, so we seem to have an affirmation situation, and an affirmation situation, at least the charter party continues. But then we've got the real problem of whether the charter party exceptions continue to apply as a matter of construction. Take an exception that says, in the incidents of the voyage, it always accepted. This isn't the voyage. He left the voyage. Yes, I've affirmed the charter party, but this deviant part is no longer part of the voyage. And so with cargo damage, the carrier may still find himself in considerable difficulties. John, sorry, John.
Is that right? If in an affirmation case, because if the charter has affirmed, does the voyage that's being performed not then become the contractual voyage or the relevant voyage?
No, I think of first principles of affirmation. You don't waive the breach. You waive your right to terminate for the breach, but you retain all remedies for that breach. And the remedy for the breach is, if anything happens due to the deviation, you're not covered unless you can get yourself into the exceptions.
Yeah.
And John, you mentioned the Gen Con Clause 2. There's an interesting argument raised by the learned authors and editors of voyage charters that the Gen Con Clause 2, the owner's responsibility clause, which says we're not liable for anything unless it's caused by our personal want of due diligence, would actually cover a deviation. Now, that's a really interesting question. But I think for the purposes of our case, as you've taken a full fat Hague Rules incorporation for cargo damage, 3.8 would, I think, must trump Gen Con Clause 2.
Isn't deviation always going to be a red herring here, Simon? We've
Why?
got a COVID-19 situation and there's a saving life exception. The chief officer was ill.
Well,
Deviation arise?
Well, hang on a minute. You've got to go back. I think the acid test is Lord Atkin. Remember what he said, and I remind myself of the words. What a departure from the contract voyage might a prudent person controlling the voyage at the time make and maintain. Now that's for the purposes of the Hague Rules exception. So we ask ourselves, when the master now leaves the contract voyage on his dogleg 12 hours off route, take each exception and ask, and the circumstances that existed at that time, not later, that time, did they justify what he did? Well, given the facts of the hypothetical scenario, Andrew, are we in a life-saving situation? I mean, just assume the chief officer is really pretty poorly. He's not well. You can't say, well, he's broken his leg. He's fantastically uncomfortable. You can't deviate under Gen Con Clause 3.
Yeah.
You're not trying to save his life. So then you turn to Article 4, Rule 4, the deviant's friend, if I can call it that. Well, then you've got this, any reasonable deviation is permitted. Now here, I think it becomes much, much more a question of fact and fact sensitive. Go back to the multifactorial assessment. Take this voyage, 12 hours off. 12 hours off on a long voyage, you just started from South Africa to China. There may be lots of delays en route anyway, bad weather, slow steaming, whatever it is. And the voyage length is a range. So he's got 12 hours off. The chief officer is plainly suffering. He's not dying, but he's plainly suffering. Humanitarian instincts kick in and say, well, I want to put him ashore to a shore hospital. Actual practical utility, yes, it would get him off. Disruption to voyage, not very much. Distance, not very much. Time, not very much. There might be a problem if the cargo was a perishable cargo, but again, 12 hours, who cares? Contrast the facts if you turn it around and say mid-Atlantic and he decides to do the same decision. I don't think that would be a reasonable deviation. And remember that ships have all sorts of procedures on board for dealing with people who fall ill, even seriously ill on board during the voyage, crew, and even who die on board. So I think you've got to take it time by time.
So the master's in the clear in our scenario then?
I think, at least in relation to the 29th of March initial decision, I think he would be in the clear. Not under clause 4, if on the facts of the hypothetical scenario he's not saving life, but under Article 4, Rule 4, for the reasons I've just given, I think it would be a reasonable deviation. But I think there's one thing that worries me about the hypothetical scenario, and it goes back to the multifactorial assessment. When the master deviated, did he know the place he was going to was in lockdown? Let's assume that 2 days before he deviated, there'd been a broadcast by the authorities of the unnamed place, the government of the unnamed place, saying all ports on the southern littoral are closed to all marine traffic for any purpose. No ships will be allowed to berth for any purpose. We are shut. We will reopen, or rather like Boris Johnson considering over and over again with dates, we will consider reopening on the 1st of July and not before then. So I think in those circumstances, there might be a real problem for practical utility, because if he knows he can't get in, why is he going? So I think we're assuming for the facts of this case that he doesn't know. He arrives, and then just after he's arrived, that port goes into lockdown. The deviation to get to that port was justified.
Couple of points. I mean, that suggests a very strict or harsh analysis of the master's conduct. I mean, do you not think that, given that the consequences of deviation are potentially so serious, as you've indicated, that a court or a tribunal is going to adopt a somewhat more benevolent approach to the master's conduct or master's decision making?
Yeah, I think it's multifactorial, and the master's in a very, very difficult position, and therefore a lot of slack will be cut to him. And, you could almost imagine the LMA arbitration where you say, ladies and gentlemen, there's a real world out there. We've heard these submissions, going back to all these old Victorian cases. I can almost hear you now, John. You then said, I think you said that you thought the master was in the clear, at least in relation to the initial decision. Yeah.
Does that suggest that you think he's going to have less slack in relation to subsequent decisions?
Yes, because if you're taking Lord Atkins' test, take and maintain. So let's assume he didn't know the port was in lockdown. He takes his 12-hour voyage. He arrives at the port. On the facts of the hypothetical scenario, the port says we're shut. We know you've got someone on board who's suffering. No one in, no one out. That's it. What does he do then? He waits. Why is he waiting? Let's assume the announcement was, we will not be open until the 1st of July for any purpose. Read our lips, we are shut. Why is he saying? Now you're in a delay situation. But if there's no reason to delay, because there's no reason to be there because you're not getting in, why is he staying? Let's assume that he thought he'd be able to persuade the authorities. And he was having some sort of discussion with the health officer and hangs on for that purpose. Now the chief officer dies. Now you're in a completely different stage of the analysis. You're not in a saving life position, sadly. Are you in a reasonable deviation situation? Why are you waiting to disembark a corpse? I mean, ships unfortunately have procedures for people who sadly die en route. Why do you wait? Especially if you're in a lockdown situation where the port authority is adamant you're not coming in. So I do see difficulties. I think delay is more difficult, but if you've got no reason for delaying, well, that's a very interesting factual question. I mean, you know, there would be an huge instinctive sympathy of a tribunal for a man in a very difficult position. But
seems like Dickensian that the master's got to turn to his chief officer and say, well, sorry, they're not taking anybody ashore. It'd be unreasonable for me to try and stay here and persuade them otherwise. We're heading off again with you literally on your deathbed.
Well, if he's on his deathbed, then he could say, that's a completely different situation. That's why you've got to get into the facts. If he's actually dying, and he's radioing the port authority every hour saying, look, this man is going to die. On your conscience, this man will be here. And he keeps trying to persuade the health authorities to let him in. Well, no tribunal or court would say that was an unreasonable deviation. But what happens when he's dead? What happens when he's dead?
Yeah, I see that may change.
So that's I think so. That's an answer to that part of the question. And then I think someone has raised a question from the audience, and it's a good question. If it was a justified deviation, does it affect the position that the master doesn't tell anybody? On the facts of the hypothetical scenario, he doesn't tell anybody. I don't think it matters, and it's a good question. Thank you very much, the member of the audience who asked it. I don't think it matters. If in a time charter situation, we said there might be differences with a time charter. I think it might make a difference because the owners have to keep the time charters fully informed. But this is a reasonable deviation. The question is posed on the basis of reasonable deviation. If it's a reasonable deviation and under Article 4, Rule 4, it becomes part of the voyage. Therefore, why do you have to send a situation report on the voyage? You just turn up at the destination in the usual way. And I think anybody should tie in the charters so that they don't turn around if the market goes the other way and they think, let's get the lawyers in and ask whether that was an unreasonable deviation, whether they're Dickensian John or not. They can pick it apart. Anyway, I think that's probably enough for deviation because I think I'm probably deviating from the contractual timetable. So let me raise the next aspect. Nichola, Andrew, safe ports. I mean, we all know what the test is. Lord Justice Sellers, Eastern City, marine perils, risks and dangers that the ordinary prudent master cannot avoid. Why does any of this really engage us in a COVID-19 situation out at Port Elizabeth or anywhere else?
Let's just take a step back, Simon, and look at the facts of this case. We've got a safe port warranty, which imposes an absolute obligation on the charterers as distinct from one of due diligence. And for reasons which I think Nichola and I will be making clear, it's doubtful whether the distinction between an absolute or due diligence type obligation will make any difference, because it seems to us that it's going to be pretty difficult to make out the unsafety of a port due to COVID-19. Now, you mentioned the Eastern City, which is still where you find a classic dictum for the nature of a safe port obligation. And that obligation is on the charterers to nominate a port, which at the time of the nomination is prospectively safe for the period of the vessel's likely visit, in the absence of some abnormal and unexpected event. The test is reaffirmed in the Ocean Victory. Once again, the factual inquiry will be multifactorial. So for instance, timing is going to be a factor. An outbreak of COVID-19 now would clearly not be an abnormal occurrence or an unexpected future event, but the position might be different if we're talking about a ship calling at a port earlier in the year. And then what about geography? That's going to play a role in the analysis, because COVID-19 was far more widespread in China, let's say, in January, than it was in the US. Whereas now, the position seems to have reversed. Then you've also got to look into the next few months and what happens as COVID-19 ebbs and is brought under control in some parts of the world. For example, in South Korea, Taiwan, New Zealand. Query whether an unforeseen second wave, which is a term we keep on hearing about, second wave, whether that might give rise to an argument in the future as to whether this was an unexpected event.
Do you think that so the existence of COVID-19 or any other disease for that matter, as a matter of principle, engages issues of port unsafety? I mean, what sort of danger or unsafety does it pose in the relevant sense to the vessel?
That's a very good question, John. I'll tell you, it doesn't involve a passage plan. I can tell you that. I don't think.
Well done, Nichola.
I don't think it's that easy to make an argument that the port is unsafe because of the risk that COVID-19 poses. If you think about the classic unsafe port cases, they usually involve navigational risks, and it's a question of physical damage to the vessel. And even though the safety of the port has by authority extended to political risks where you visit that vessel, those risks are ones which put the vessel in danger of being seized or physical harm at the port to which she is then proceeding or has proceeded to. So I don't think it'll surprise anyone here today that there's not been any reported decision which is on all fours or gives the answer to that question. And there have been two possibilities put forward in the legal tests. I will put my hands up straight away and say that I am far from convinced that either route is going to successfully happen, but I will identify those and I'll explain why I see there are difficulties with them. The first route, the danger that we're looking for, John, is the danger to the health of the ship's crew because of the risk of contagion of COVID-19. Now, the reality is that crew are always exposed to some measure of risk from whatever people come on board from the shore. And there are various measures which can be taken to implement to control access to the vessel, or health and safety measures to avoid or minimize the risk where there is a ship-to-shore interface. So if you were going to argue that the port was unsafe because of this risk, then it's going to involve quite a detailed examination of the level of the port's precautions and protective measures. And as a matter of fact now, it's unlikely that a port has no such measures in place. So it's going to be a question of degree. And also one has to bear in mind that this is not a situation where you can look across the ports worldwide and see they've been able to take uniform measures, because different governments have responded in different ways. We've had the 2 meters, 1 meter, masks, no masks. And ports, like any other business affected by COVID-19, are restricted in what they can do by the government advice that they've been given. And there has been no global advice. The IMO gave some basic advice in May of this year about ship-to-shore interfaces, but there's no uniform approach. So I think this one, yes, in principle, there could be a danger, but in theory, a contagious disease, yes, it can render a port unsafe, but in practice, I think it's going to be very difficult to prove this type of unsafety. The second route is where I think there's more of a problem with principle. That the second route, which has been suggested by one tiny little paragraph in Voyage Charters and now been leapt upon by various commentators after COVID-19.
I wonder who's responsible for that paragraph.
Identifies the danger as being that the danger that the vessel will be blacklisted, detained or quarantined or impounded, not at the port which you're now alleging is unsafe, but at a subsequent port. So, the authority which is cited in all the commentaries and as number one in the footnote to the Voyage Charters is a decision called Chiampa and British India Steam Navigation. That was a case where the vessel had called at Mombasa, then went to Naples to load a cargo of lemons, and then went on to Marseille. At Marseille, there was a long-standing decree that any ships who had been at Mombasa had to be fumigated because of plague risk. And so that's what happened, with pretty obvious consequences for the cargo of lemons. You will search in vain in that case to find the word safe port. Or
it's an unseaworthiness case rather than a safe port case.
Oh, John, back again.
Yeah, no passage plan though, John.
No, John. Not a legal case.
So there were sort of two arguments. That the decision was actually that you couldn't rely on the restraint of princes exception in the Bill of Lading, but it did talk about unseaworthiness. And it was held that the vessel was unseaworthy, the rationale being that it was inevitable, bearing in mind everyone knew about this long-standing decree in Marseille, that the ship and cargo on the course of this voyage would be subject to fumigation and unfit to receive or carry cargo. But as I said, the case doesn't say Mombasa was unsafe. It doesn't say that it was unsafe because of the risk of fumigation at Marseille. And so to cite that as authority for the proposition that a subsequent detention might render a previous port unsafe, I think is stretching the analysis.
Problematic. Let's assume for the moment that, as a matter of principle, the existence of COVID-19 at a port could constitute unsafety in the port. On the facts of our case, do you think either of you that the case would be made out on the facts? Was Port Elizabeth unsafe?
Andrew, why don't you deal with the risk of contagion to the crew first, and then I'll come in with my favourite. I don't think this works as principle.
A beautiful pass of the ball.
Sorry, Andrew.
Yeah, well, I've got the easy bit. Well, John, I think the answer to your question is probably not. Nichola, you've pointed out that a key question is going to be what systems were in place to control the risk of COVID-19, and ports with compulsory pilotage like Port Elizabeth will have risk management systems to deal with face-to-face contact between pilots and masters. That contact can't be eliminated without shutting down the port. So let's assume such measures are in place, because it's pretty much inconceivable that a port is not going to have such measures nowadays. On these facts, and as one member of the audience has pointed out, it may have been the master who had taken a number of flights to get to Port Elizabeth and had been carousing on shore, who brought the virus on board. And
carousing, Andrew?
Another Dickensian
yes, yeah, draw a veil over carousing.
So if it was the master who brought the virus on board, well, that's probably the end of the story, because that's not a feature of the port. That's a consequence of the master having to come on board because of a changeover, and it's a result of the master's activity before he came to Port Elizabeth. Now, let's assume, if you want to make life a bit easier for the owners, that you can show it was a pilot who brought the infection onto the vessel. Well, there's a system in place at this port. Someone slipping through the port's safety net might well be characterized as an abnormal occurrence.
Yeah.
And if the pilot doesn't physically or socially distance from the master during pilotage operations, that might be characterized as an isolated act of negligence. And that wouldn't render the port unsafe either. And even if you could overcome these hurdles, you've got to ask, how might the risk to the crew sound in liability for a breach of warranty? Nichola, you're going to be discussing delays due to quarantine. Now,
yeah, I mean, as I say, I think that's difficult as a question of principle, but on the facts of our case, it's really difficult, because we don't know that she didn't get into the port to which the master deviated because she called at Port Elizabeth at all, because there was already either a lockdown in place or about to become imposed in place. And you also had a very sick chief officer and then a corpse on board. So there are lots of reasons why she didn't get into that port. And there's no suggestion in our scenario that she had any problems going to China. And I think this sort of demonstrates the reason why I think it's so difficult. Imagine if you had two ports treating the previous port of call very differently for very different reasons. Is it unsafe for one purpose of a port and not unsafe for the other? I think this is a very difficult area to argue that the port is unsafe.
And you've got difficult factual questions. I mean, if you really do have a virus that lasts on metallic surfaces for up to a week, and she called at two ports, say a container vessel, on very, very quick rotation between ports, how are you going to prove where it was on? You know, whose procedures broke down that allowed someone to put the COVID virus on a handrail which leads up to a bridge wing? It's very difficult, I think.
Exactly. So I think we have some time for questions now. To kick us off, I'm going to go with one that we've received in advance, and then I'll look on the question and answer function. So if anyone wants to raise a question that they haven't put on the chat or question and answer function that I'm going to look at now, please do so. John, the first question is for you on seaworthiness. And it's sort of a twist on the scenario. Imagine that one of the measures implemented at Port Elizabeth is that it requires all vessels calling there to have some sort of medical supplies over and above those that the vessel's flag requires. Somehow the vessel is snuck in without having those, but it still doesn't have those additional medical supplies before it departs for China, do you think that this would render the vessel unseaworthy? Just the mere fact of not having these additional supplies?
Get out of that, John.
That's an interesting question, but if it depends, I suppose, whether the lack of supplies prevents the vessel leaving the port or not. If on the facts that the vessel is able to leave the port, then the lack of supplies is unlikely to have caused any problems. It certainly raises interest. If the result is the vessel arrives at the port but then isn't able to leave, that certainly raises very interesting temporal questions as to when the obligation to exercise due diligence to make the vessel seaworthy for that particular voyage commences. So it's an interesting question.
I'm not going to ask the follow-up question, which is whether
you are.
China implementing it. I'm not going to ask that one, Simon. I'm looking for a deviation one for you on the chat log, but no one's given me one on video.
There is one. I've got one.
Actually, let me answer that. I've just seen the follow-up question, because the follow-up question I think is actually rather easier. So the follow-up question is whether the absence of medical supplies then prevents the vessel getting into the disport.
Yes, exactly.
And that seems to me rather easier, because if the vessel isn't able to complete the voyage because she didn't have kit that she should have had before the commencement of the voyage, then that is unseaworthy.
Absolutely.
There are a bunch of cases. I mean, for example, the Madeleine, where the vessel didn't have a de-ratting certificate, and that caused delay and so forth. So I think that's a rather easier question. It's absolutely typical that you ask the difficult one and miss out the easier one.
Very, very.
No. I was thinking about the temporal link. I was going to lead you the whole way through.
And very good, John. That is almost like a Black Death reference to the de-ratting certificate. Carrier of viruses. Fantastic.
Very nice.
But I've got to do
Simon, I have a question. For deviation, I think it's really the scenario you were considering is how foreseeable does it have to be that the port might be closed? To which you want to make your deviation. So the question is, would the test be whether a prudent master would be able to foresee that the port was shut? And if yes, would that make the decision to deviate unreasonable?
Well, I think then you've got Lord Atkins' test. Prudent person controlling the voyage at the time he decides to deviate. At the time, the port either is or isn't closed. If it isn't closed, then he may foresee that it may close, but how will he foresee when it's going to close? 12 hours. So I think he's perfectly entitled to continue on his way. If 6 hours in, the port says we're now closed, and we've heard your radio request to put the chief officer off, our shoreside hospitals are completely barred to anyone from foreign ships, including ships already at anchorage. So please don't ask us. Then a different situation arises. So I think there's a question of foresight, circumstances which arise at the time, and if it's locked at the time, then you shouldn't be going, is one possible argument.
Okay, John, I have another question for you on due diligence this time.
Yeah.
We talked really about the due diligence and people having to shop themselves if they feel sick and so on. Have the owners arguably failed in their obligation to exercise due diligence in this case by not having a quarantine procedure for the incoming master during the crew change?
Well, that is again a very fact-specific question, and I think you would need to look at what it was reasonable for owners to do at the particular time that this crew change took place. Certainly, certainly as a matter of principle, if the risk of COVID-19 was sufficiently well known at the time, that a quarantine period was sensible to prevent disease being brought onto the vessel, then a failure by the owners to put in place a quarantine system would be a failure to exercise due diligence. It goes into a number of respects. First of all, if it results in the vessel being unseaworthy, that's good enough in itself. There's also an argument that the vessel's unseaworthy if there simply aren't proper systems in place to prevent disease. So again, it depends on the facts that are known at the time. But if you can establish by evidence that the reasonably prudent owner would have quarantined crew at that point in time, then there would be a failure to exercise due diligence on the part of the owners in not having an efficient quarantine system in place.
Yeah. Okay. There's been a comment really, again, on the illness of the chief officer and unseaworthiness, John, that the chief officer is always included in the safety manning minimum certificate. So could it be argued, if he's taken to his bed, that there was a deficiency of men on board at that time because he could not perform his duties?
Yeah, I think that supplements the argument that the vessel is unseaworthy by reason of his illness. It seems to me that proper manning is an aspect of seaworthiness, expressly so in Article 3.1. And if he is, if at the commencement of the voyage he is going to be unable to perform his duties during the course of the voyage for whatever reason, then I think that would constitute unseaworthiness.
And it raises an interesting aspect in relation to deviation, because if in the master's mind, as part of that multifactorial assessment, let's assume that the chief officer, the first officer have gone down, no one's suspected of there being a life-threatening situation, but they've gone down and unable to perform their duties, and the second officer has now developed a very bad cough. He now decides to put into port 12 hours, 24 hours, 72 hours away, to get them off, but also is radioing ahead to try to get replacement crew members to fulfill what might be a long and demanding voyage. That, I think, you're in very easy territory for reasonable deviation there.
Simon, to what extent, when you're applying the multifactorial test, can you look at the reason why the need for deviation has arisen? Does a deviation become less reasonable, or is it less likely to be held to be reasonable if the need for it has been caused by something that the owners did themselves?
If the owners did themselves, I mean, if the deviation results from, if the need to deviate results from a breach of charter party, then is it a reasonable deviation? So take, for example, your example, a good example of the de-ratting certificate, but switch it to the medical supplies, which remember the audience asked. Let's assume that the vessel sets sail with a completely inadequate stock of medical supplies. They radio in accordance with ordinary procedures to the international ship's doctor, radio service, and the ship's doctor says, give him X drug, Y drug, and inject him with this. You'll have it in your standard kit. They open the cupboard and there's nothing there. They have to deviate to get that man off because now he's in a bad way, which would have been easily remediable, not COVID-19, some other disease, easily remediable by use of ordinary ship supplies. Is that a reasonable deviation? I'm having to deviate because I don't have on board what I should have had on board at the departure of the voyage. No. Nichola, there's a question that's popped up on my Q&A from someone who I know very well. Thank you very much for this question. It says, if as a result of the deviation a charterer or trader misses the contractual arrival window and the vessel is delayed berthing and incurs significant demurrage, would charterers be able to resist the demurrage claim on the basis of the deviation, irrespective of whether the deviation was justified or not for the purpose of saving life? I think that raises a very interesting question. I mean, under the Hague Rules, Article 4, Rule 4, the deviant part of the voyage is not treated as deviant if it's for a reasonable deviation and becomes part of the contractual voyage. And Article 4, Rule 4 says, shall not be deemed to be an infringement or breach of this charter party, and the owner shall not be liable for any loss or damage resulting therefrom. So I think you can't say, yes, the deviation was reasonable, yes, it was justified, but you caused me demurrage. It's part of the voyage. My answer to that question. Are there any safe port questions? Are there any safe
I had one on safe port question for Andrew, because he's left out there.
Go on, Andrew.
Come on, Andrew, I promise you'll be able to answer this one. It's a question on causation on our factual scenario. And the suggestion someone is saying is, here, can't we assume that the unsafety was because it was the master who came on board and transmitted it to the chief officer? Where is the contact with the port here to generate any unsafety by reason of the port. So the question here believes the only possible risk of contagion came from the master. Do you agree with that on our facts?
I don't think the scenario presupposes that the master is the only possible vector, because we can see that one of the pilots tests positive, and the difficulty is ascertaining whether it was the master or the pilot. Now the contact point comes in because the pilot boards the vessel and has to be present during the pilotage procedure.
And we have the two pilots in this case, don't we? We have the inbound as well as the outbound. So it could have easily been the inbound pilot that brought the vessel in, rather than assuming it's the master or the outbound pilot, correct?
Yeah, quite.
Yeah.
But that is why it's going to be factually quite difficult to establish how the virus came on board in circumstances where you've got multiple candidates and you've got a situation where one of them could have passed it to another crew member. You could have a chain of infection, which is difficult to trace. I mean, contact tracing is difficult enough on dry land, but what about
especially in the United Kingdom?
Yeah, quite. So it does raise a really difficult question, and I would be interested to see how a trial would proceed on this issue, because you might end up with an epidemiologist explaining that the likelihood is it was the master who gave the virus to the chief officer because they spent more time working together, they were living in close quarters, the pilot was only on board for 15 minutes, things of that nature.
It's been very difficult in the fact. I mean, you know, with 8 different incubation periods and symptomless carriers and so forth. I mean, how do you prove that it's something that happened at port A rather than a previous port line anyway?
Yeah, and that also means it's going to be difficult for any port to guard against someone not being infected and being at work, because they could be asymptomatic. And if that's the case, then you just have no way of stopping them from coming to work, boarding a vessel, infecting a ton of people if that's what happens, and then disappearing off into the night. And you can't actually implement a system which prevents that unless, I suppose, you've got someone at the gate of the port jabbing everyone with an antibody test.
Yeah.
Right, well, reluctant as I am to draw this webinar to a close, and we haven't had the interesting debate in the unseaworthiness issue, which would arise out of the application of my and John's case in the Supreme Court, Volcafe and CSLE. If that sort of reasoning applies to unseaworthiness, just arising out of the discussion, the instant discussion between Andrew and John just now, as to does the burden of proof create a problem? Because on who the burden of proof would be. Would it be enough for the owner to say, well, you can't prove where it was, or if the charter turns around and says, sorry, it's not my burden? Anyway, that possibly is for another seminar, and I'm not saying any more about it because of a certain trial that's brewing in November. But I'd like to thank members of the audience very much for joining us. I hope you found it an interesting and enjoyable session. We've certainly enjoyed having your very interesting questions. I'm sorry we weren't able to get around to them all. You've asked a lot, but time is, we need to keep this strictly within the hour, so we're closing now. Can I remind you all that the next shipping special Quadcast is on the 21st of July, and it's going to be hosted by an equally stellar, shall I say, a group of quadrant members of chambers on very, very interesting topic of letters of indemnity and the particular problems that are coming up with letters of indemnity given pandemic issues. So I hope you'll join us for that. Very nice to see you all, even if only virtually. Hope you all keep very well and have a very good afternoon. Goodbye all.